Chester Burrows.
Thank you, Mr. Speaker. And I'm privileged to be able to take this opportunity to speak in respect of this bill and maybe to answer some of the questions that have been raised in the course of other speeches. It's difficult to cover in any real significant depth the large number of issues that are raised, but important to speak about a number of them. And over the course of previous consideration of the bill that's currently before the Justice and Electoral Select Committee, we've heard a large number of submissions in respect of a number of these issues too. And probably the most common submissions that have been made have been around the lack of the ability of local people to be able to impact the consent procedure in granting consent applications on the basis of proliferation in local communities. And I find it most frustrating to hear from people who have been in this House for a long time, who are critical of where this bill doesn't go, knowing that they sat by largely on their hands while these laws were promoted that didn't allow local people in their own communities to be able to submit, for instance, on the placement of a liquor store across the road from a school. For instance, we have the situation in Glen Innes where young people can walk across the road from their high school in school uniform, purchase an RTD for about $1, drink it and go back to school in that afternoon, supposedly to carry on with their schoolwork. This bill will allow for local alcohol plans and will allow local people to be able to impact that consent process, and so it should. It's also ridiculous to think back to a time when this Parliament decided we should all start drinking like the French and turn a blind eye to the alcoholism problem that they have in their country, far more significant than what it is in our country, and try and address, for instance, our beer drinking, binge drinking culture by way of legislation, because the point has already been well made that legislation will not change that culture, only a change of attitude will. And so the bill seeks then to impose onto parents and caregivers the liability for alcohol that they supply to those people who are minors, and requires that if they are going to supply alcohol to minors who are not their children, then they need to have a positive authorisation to do that from the parents and caregivers of those people. Because at the moment we live in a country where if a parent wants to put on a 16-year-old birthday party for his child, where that 16-year-old can invite all their friends, he can pull a pallet of booze in the garage and say go to it, and commits no offences. Traditionally our sale of liquor laws within this country have been a dog's breakfast, and what happens is that governments periodically titivate around the edges of it, try and tinker with it, and every few years they have to have a major overhaul. And in respect of what has been done in the last few years, this piece of legislation is a major overhaul. And it may well be that members on other sides of the House are not happy with how far it goes, but it is significant as it addresses, for instance, retail outlets, the hours in which alcohol can be sold, the supermarket component of the alcohol industry, which has grown out of to such a proportion that 70% of our alcohol consumed in this country is bought from supermarkets, and then tries to deal with the quandary of the fact that supermarkets are probably, and are in fact, the most compliant sellers of takeaway alcohol in the country in terms of not serving to underage and not serving to intoxicated. But at the same time, they must bear the responsibility of having supplied, through their retail outlet, the vast amount of alcohol that does cause problems for our law enforcement agencies, for our families and for our social agencies. This bill also seeks to deal with the conundrum around ready-to-drinks RTDs, which have become very much the gateway product of choice for young people starting drinking, where mature adults, supposedly in charge of companies, have made alcohol and advertised it as alcohol that doesn't taste like alcohol, alcohol that is tasting like lolly water, in order to be able to entice people at a young age to start drinking alcohol and then to maintain them as clients of their particular brand. This bill seeks to limit the alcohol content of RTDs to 5% and limit it to 1.5 standard drinks. We're expecting within the Select Committee to have some discussion around that and some concerns raised by that sector. But the other thing we must recognise too is that every different part of the alcohol sector is standing there pointing at another part of that sector and saying that they are the ones to blame. In fact, this bill seeks to address to limit the activities of every part of the sector and deal with them as a group, and that is a good thing. I take issue at some points that were made by speakers on behalf of the ACT Party and on behalf of the Progressive Party. I find it absolutely abhorrent that someone can be in Parliament from the early 80s and having stood, maybe voted certain ways, but taken largely no public role in condemning the use of alcohol over well over 25 years, and then seeks to talk to people who are, for instance, involved in the wine industry or the retail grocery industry and call them drug pushers. I find that absolutely ridiculous. I also take issue with the ACT Party, who is prepared to push and promote the 3 strikes legislation, people who are committing offences against the person largely by the intake of alcohol, and then want to further liberalise and won't seek to limit or vote for this bill which seeks to constrain people sourcing alcohol, which is the very firewater that creates those offences in the first place. I think it's also important to note, in respect to comments made from the Green Party and the Maori Party in respect of where we get to on infringement offences, to note this. Currently, the law around liquor bans that are operating all around this country are such that there is a power of arrest that goes with it. And at various times of the year, for instance New Year's Eve, we have a situation in some of our resorts where you've got 160, 170, maybe 200 people arrested, taken back to the police station, confined in a cell for several hours, and then let go on the basis that they had liquor in an open container in a public place. And what this bill seeks to do then is to create an infringement offence for that, so that that detention is not required. And but at the same time allows for the short-term power of arrest so that they can be dealt with, but then, for instance, given an infringement notice and let go without the need to go through the fingerprints, photograph, and now DNA, it's not DNA, sorry, but the fingerprints and photographing process so to streamline that infringement on their liberty. I note that there has been a negative Bill of Rights report from the Attorney-General. They are issues that I look forward to dealing with within the Select Committee process, and no doubt they will be debated vociferously, as I would expect within that committee. We discussed the prospect of this bill coming before the committee this morning, and we're all looking forward to dealing with it at a number of locations around the country and receiving submissions from as many people who want to engage with the committee around this debate. Thank you, Mr.